Good afternoon, everyone. It is Tuesday, March 25th, and I call the meeting of the Senate Elections Committee to order. A quorum is present, and we have 4 items on the agenda today. If we're not able to finish our work, we will need to meet on Friday morning. Today is the Westlin Bill Day. So the first bill is Senate File 1812, Senator Westlin prohibiting election-related bribery. So Senator Westlin, would you like to move your amendment, or would you like to describe the bill first?
Well, Mr. Chair, the A2 amendment is a delete everything amendment. I do have one very small oral amendment to the A2 that I would like to offer. In line 1.14, we would be deleting the word materially and instead inserting the word directly.
Accept the amendment first.
Yeah, so
The oral. Okay. Yeah. Thank you, Senator Westlin. And what we need to do is we need to have the Council Stango repeat the oral amendment to the amendment.
Thank you, Mr. Chair and members. On the A2 amendment on page 1, line 14, delete materially and insert directly. And Mr. Chair, I think you could just incorporate that amendment into the adoption of the A2 so you don't have to vote separately.
Okay. Thank you. Thank you. So we have the A2 amendment as amended, and it is an author's amendment, so we can just vote that one in. So all in favor, say aye.
Aye.
All opposed, nay. The amendment is adopted. Senator Westlin.
Thank you, Mr. Chair, and thank you, members, today for considering Senate File 1812. This is really an anti-bribery bill. Over the past week, news stories have reported on the big money pouring into the race for Wisconsin Supreme Court. That race is now the most expensive judicial race in American history. The 2 campaigns and IE groups and others have spent more than $73 million. The AP reported that Elon Musk's Political Action Committee has not only spent money directly on the race, but the PAC, whose largest funder is Elon Musk himself, is now offering $100 to Wisconsin voters to sign a petition, quote, in opposition to activist judges, unquote, and an additional $100 for each petition signer they refer. Such schemes prey upon those who may be experiencing financial difficulty and is a clear attempt to buy influence with voters. We have frequently discussed the role of money in our elections in this committee and the corrosive effect it has on our elections, especially since Citizens United. We have an opportunity today to draw a line in the sand in Minnesota and say no to billionaires bribing citizens for their votes. This bill expands the current prohibitions on bribery. Specifically, this bill prohibits attempting to induce a registered or eligible voter to sign a petition directly related to an election or attempting to influence an individual to register to vote. Importantly, the Attorney General and the county attorneys are given new civil enforcement authority over violations. Billionaires and dark money continue to undermine our democracy and the influence everyday people have on their own government and who represents them. Pew Research found that 83% of Republicans and 80% of Democrats believe that people who donate a lot of money to campaigns and IE groups and PACs who are funded by dark money have too much influence on the decisions made by their elected officials. 72% of the public supports limiting the amount of money spent on campaigns. And nearly 60% of people believe it is actually possible to have laws that would effectively reduce the role of money in our politics, and this is such a law. To do a quick walkthrough of this bill, Mr. Chair and members, lines 1.5 and 1.6 would make a person guilty of a felony if they willfully, directly, or indirectly advances, pays, gives, promises, or now provides a chance to win, or lends money, food, etc., to induce a voter to register to vote, or to induce a registered or eligible voter to sign a petition that is directly related to an election. I believe, Mr. Chair, that this is a provision that will help protect our elections, the security of each individual's right to vote, and it will send a message that we do not want billionaires coming into our state attempting to bribe our citizens and influence our elections. And with that, Mr. Chair, I believe we have 2 testifiers on this bill.
Thank you, Senator Westlin. We have 2 people who are on the list. Mr. Paul Huffman from the League of Women Voters of Minnesota, and Ms. Mary Hartnett from Clean Elections, Minnesota. And either of you can start out. We have Mr. Huffman listed first, so if you'd like to start out.
All right, thank you, Mr. Chair and members of the committee. My name is Paul Huffman. I'm the Elections and Redistricting Policy Coordinator for League of Women Voters Minnesota. League of Women Voters is a nonpartisan organization. We have policies based on long studies, based on facts and history. We don't work in support of any party or candidate, but really focus on the vital issues concerned to our members and the public with the interests of voters in mind. We support policies that ensure that elections are not distorted by the influence of spending by wealthy individuals and political action committees. And we've spoken with this committee before about those concerns and other instances. The emerging practice of offering cash awards to voters for signing petitions, pledges, or other shows of support for candidates, candidate positions, candidate slogans presents a new and singular challenge to the integrity of elections by directly injecting cash from political action committees and individuals to voters. This is not free speech. This is not funding campaign information. This is directly using money to influence voters. It is not buying their vote. However, my experience in business, nearly 28 years in corporate America with an MBA, is that it's long established that businesses and organizations create affiliation, create a sense of loyalty by offering something of value to individuals, their customers. So that's recruiting people into that. Now that's okay if you're talking about a business and trying to grow your customer base. It is not acceptable once being discussed is getting people support for a particular candidate or position in an election. So this is, in a way, marketing, but it is marketing not for business purpose. It is for influencing outcome of elections. We think that this practice and its expansion presents a significant potential for vast escalation by all groups and parties to put more money into these kinds of mechanisms unless there's provisions that would require them not to. Our concern is that this appears to be initially, when this first came up last fall in Pennsylvania, that this surely had to be against the law somehow. But yet nobody has found any provision of statute, either nationally or at a state level, in which it would be prohibited. So, we feel it's critical that action be taken at this time, at least for Minnesota, that we stop this progression. We thank the author for bringing this forward and for her receptiveness to some feedback from the League of Women Voters and others, and we ask you to support this bill. Thank you.
Mr. Huffman, and now we have Ms. Mary Hartnett from Clean Elections.
Mr. Chair and members of the committee, thank you for the opportunity to testify today. My name is Mary Hartnett, and I'm the Executive Director of Clean Elections Minnesota, a nonpartisan nonprofit organization that works to build a healthy and inclusive democracy by limiting the power of big money in politics and protecting the integrity of our elections. We were founded by a former chair of the Campaign Finance Board who was appalled by the unlimited amount of dollars that were going into campaigns after the Citizens United decision. And we want to thank Senator Westlin for introducing this bill and offering this amendment. We strongly support the SF 1812 DE amendment and bill because it addresses an alarming practice that's happening in Wisconsin, as mentioned before, a super PAC funded by a billionaire offering registered voters money in exchange for their signatures on a petition against a sitting state Supreme Court justice they also seek to defeat. The same PAC, super PAC, offered $100 for registered voters to sign similar petitions in swing states during the 2024 elections and a chance to enter a lottery and win $1 million a day. This is bribery, plain and simple, and threatens the fairness of our democratic process. Regardless of party affiliation, this is a practice that's an affront to Minnesota values. Minnesota can be a leader in taking a stand and saying no to corrupt practices such as these. And why it matters, it protects our election integrity. Paying voters for signatures creates the perception of vote buying, eroding trust in our system, and raising concerns about whether political decisions are being made based on merit or financial incentives. It curbs wealthy influence. Super PACs backed by billionaires already distort our elections. Without action, we risk creating a new, unchecked form of campaign spending, one that allows deep-pocketed donors to influence voters outside of the candidates themselves. And it helps to restore public trust. When money, not merit, determines outcomes, public confidence in our institution crumbles. SF 1812 strengthens anti-bribery protections to maintain faith in Minnesota's democratic process. We also recommend strengthening 1812 by, in another way as recommended by the League of Women Voters, establish a clear timeline. Prohibit this activity from the start of absentee ballot through Election Day to prevent undue influence at the critical moment in the electoral process. Members, democracy and our elections should not be for sale. Big money should not be able to buy our elections. Allowing financial incentives to influence petition drives in elections gives an unfair advantage to the wealthiest individuals and PACs, further tipping the scales against everyday Minnesotans. Senate File 1812 is a critical step toward ensuring that our elections are determined by voters, not money. We urge you to vote yes to protect the integrity of our democratic process. Thank you.
Thank you, Ms. Hartnett.
Mr. Chair, if I might, I do want to clarify, Ms. Hartnett brought this up, but this amendment does include a specific time period.
Oh, good.
And this does restrict this activity during the period beginning on the first day of the absentee voting period for that election and ending on Election Day. So we have addressed that concern and made sure that this is applying to a very specific time period.
My bad. Thank you.
No, that's okay.
Thank you, Senator Westlin. Now it's time for any comments from members. Senator Grant.
Thank you, Mr. Chair. Thanks, Senator Westlin. I'm not sure this is a problem. I think you guys described it as could be a problem. We could make it illegal. I find it, again, I'm always interested and entertained by the hatred for dark money, for which the Democrats are extraordinarily beneficiary or have a pretty good head start on those dollars that are laundered through to maintain their anonymity all through many different processes. This very entity, talking about dark money, this body here, I think I carried the ban the Zuckerbucks. Remember, he was a good billionaire in Democrat terms in 2020. Now he's a bad billionaire, I guess, so he's not good. But voted down banning these dark money, as you describe it. You voted down to ban those things when they piled $420 million into elections in 2020. We've carried that bill nonstop, and it came in different forms, right? It went in mostly completely Democrat-led cities. Where they took these dollars. It went into some nonprofit entities that were part of the Democrat campaign apparatus, but it was good money. It was good dark money then. To go out and constantly vilify, again, they got to operate in the law, and I get you want to change the law, but I think it's interesting that this body here on the opposite side would not vote against it. So we look forward to your enthusiastic support to ban Zuckerbucks and all of those things into the future. And because I don't know that this solves a problem. That hasn't happened in Minnesota, I get it. Knee-jerk reaction, something happened in Wisconsin. I don't know the numbers. I guess the question I have, Senator Westlin, is of the $73 million that's been spent in the Wisconsin race, do you know the breakdown of that?
Senator Westlin.
Mr. Chair, Senator Cran, can you clarify your question? Like, what do you mean?
Senator, yeah, Weston, is the you mentioned that race that this bill is reaction to, that they've spent $73 million on that. Is there a breakdown? Is that Republican, Democrat, conservative, liberal values? What is it?
Well, I can.
Senator Westlin.
Thank you, Mr. Chair. Senator Curran, two of the biggest spenders in the race are America PAC and Building America's Future, which have both spent over $14.3 million, which is $1 in every 5. That's an article from the Brennan Center breaking down the spending. I believe those are the two biggest spenders, and those are reporting well, it's a nonpartisan race, but they are supporting the candidate who aligns with the Republican Party. So in terms of outside PACs, that those are the two biggest ones. And I do want to say one other thing with regards to Zuckerbucks and other things. I wasn't on the committee. I don't know how many other people on this committee were on the committee at the time, but dark money is dark money. Billionaires are billionaires, regardless of which side of the political aisle they align themselves. It does seem that like the billionaires do seem to be lining up behind Donald Trump as they did at the inauguration. I just think it's a bad idea for billionaires to be bribing citizens.
Mr. Chair.
Senator Grant.
Thank you, Senator Westlin, and I agree. You haven't been here. The chair has been here. The chair's been here and voted down and led that vote. So I only use the term good billionaire, bad billionaire based on the former Democratic chair of Minnesota and his campaign speech where he clarified the good billionaires is what he would like to accept money on. So we might be able to find some agreement on some of this. I don't think this is going to go anywhere. And so I think it's a knee-jerk reaction to a bill, something that hasn't happened here. I think it would take more thought and process about if we're going to actually, if you want to do dark money, then we probably should go after all of it. And this doesn't do that. And so, Mr. Chair, I don't think the House is going to pass this bill. It won't go anywhere. But I'd like to request a roll call on this vote.
Mr. Chair.
Roll call requested. Roll call.
Thank you, Senator. I was also hoping for a roll call.
Senator Westlin.
I don't think this is a knee-jerk reaction at all. I think we have seen this happening, and it's happening right next door to our state. We have an election in 2026. 201 legislators will be up for election. We will see statewide elections. I think it's coming to our state, and I think that being reactive instead of proactive is not a great way to address things that are so egregious and so serious. And lastly, I will look very forward to working with you, Senator Cran, to address the issue of dark money in our politics. Certainly, we can't really count on the federal government to do things, but I think we should be doing what we can in our state to protect our citizens and to make sure we have actual transparency when it comes to funding our elections.
And I guess I must say something about when you mentioned that I was here at the time when we did vote on Zuckerbucks, which I kind of reject that terminology, but that was a different situation than what we have today, because what we had at that time was that locals had to request an application of dollars, and those were supposedly used for the to fund the voter needs in a particular district. And I remember in that committee meeting asking you, because your town did get some of those Zuckerbucks, and I did ask if you knew what they were used for, and you were not quite sure of it. But the fact of the matter is that they were not given for a particular candidate, like these are given for a particular candidate. So there is a difference there.
Mr. Chair?
Senator
Mr.
Grant.
Chair, so I guess if you define the terms and conditions, dark money's good, and we fund elections, and so it's an obligation and role of each of our municipalities in the state to fund those elections. Yes, one went to what was probably my most Democratic city, and probably Democrat mayor requested $5,000. Probably used it for something in elections. It almost went exclusively to Democrat-led cities, where they allowed them to take over the operations of a city, of a city elections. And so to hash around the terms, as long as you get to define the terms and conditions, that it's just suddenly good dark money, I don't buy that story as well. And everybody here that served in the 23-24 legislative session voted down the Zuckerberg amendment on the floor multiple times. So we'll work on the dark money, Senator Westlin.
Great. Mr. Chair,
Senator Weston.
interesting discussion, but I do want to refocus us on this particular bill and this particular problem. This is a problem. It was a problem in 2024. Could just as easily be a wealthy billionaire doing the same thing for Democratic candidates. I would have the same opposition if that were the case. And I want to be very clear that this, again, is about protecting our voting system here. It is protecting voters, especially voters who may be experiencing some kind of financial difficulty, who might be enticed to participate in something like this, where they are promised, whether they actually receive the money is a different question, but where they are promised money in return for signing a petition related to an election. So this is very narrow. It goes to the bribery statute. We already have anti-bribery laws, but this does add one more very particular thing to our anti-bribery laws. And so I would like to see if we can't stay focused on the bill at hand.
Thank you, Senator Weston. Senator Bolden.
Thank you, Mr. Chair. Thank you, Senator Westlin, for your work on this bill. And I appreciate your refocusing us on what is actually before us, which is addressing a problem that is happening right now. And it is egregious and wrong, and I am grateful that we are talking about it and taking action. I mean, clearly this should not be legal. Clearly, it's one billionaire, Elon Musk, who is doing this right now, but that's, it opens the door. There definitely are other billionaires who could step into this space and do this as well. And so, this practice is really exploiting a loophole to skirt around campaign finance transparency to potentially prey on people and influence our elections. And so we should absolutely take action and stop this. And so thank you for this work. I also am grateful for the discussion to hear about the desire of members of this committee to work on the issue of dark money in politics in elections. But just to say, our hands are our toolbox in that regard is limited because of Citizens United. There are not endless measures that we could do to completely end that. We just can't. And so we have limited options for that. And this is one of the things that we can do. We'll hear another bill on Thursday that I look forward to voting for as well, with original source disclosure. But there aren't a whole lot of things we can do in this space. This is one of them that we can, and we absolutely should. We should close this loophole, this exploitation, this activity that should clearly not be legal, bribery of voters. And so thank you for bringing this bill.
Thank you, Senator Bolden. Senator Lucero.
Thank you, Mr. Chair. One of the things that I hear about from Minnesotans who reach out to me before I was a member of this committee, now as a member of this committee, reaching out to me via email, via in-person meetings, via phone calls, is they are very frustrated with the intellectual dishonesty. And so while I very much appreciate this conversation, when the topic of Zuckerbucks is brought up, and Mr. Chair, you say that it is different. It is not different. I wrote down, as the chief author of this bill was speaking in the opening remarks, billionaires influencing elections. That was the very words to gain support for this. And the difference here is, and I love how Senator Cran characterized it. It's good dark money and bad dark money. It's good billionaires and bad billionaires. And Democrats have this selective outrage against Elon Musk and characterize him as a bad billionaire, but they are all googly over Mark Zuckerberg and when he was directly influencing elections. Every Democrat that is sitting in here voted down those amendments, whether they were a member of this committee or not, because those very Zuckerberg amendments were offered on the Senate floor. And that's the intellectual dishonesty that Minnesotans are frustrated over.
Senator
And so
Lucero,
one of the things that I'm
Senator
looking
Lucero,
for.
I think you need to tone down that. We're not talking about intellectual dishonesty. That is not correct. And I'll answer what you have accused us of as soon as you're completed with your statement.
Okay, thank you, Mr.
Senator
Chair.
Lucero.
So what Minnesotans are looking for is integrity. They're looking for integrity and consistency. And if we're going to say that billionaires influencing elections is a problem, then whether the dollars come from Elon Musk, whether the dollars come from Mark Zuckerberg, or whether they come from any other entity that is unduly influencing elections, that's what we should be concerned about. And unfortunately, Democrats have this selective outrage, and it's very frustrating. It's very frustrating. And Minnesotans are frustrated as a result. But they see that they can see the blatant transparency in the efforts here. Thank you, Mr. Chair.
Mr. Chair.
Thank you, Senator Lucero. I just need to say one thing is that in the case of what we have referred to as Zuckerbucks, there was no strings attached to that. A voter was not asked to vote one way or to respond one way that you would say is a partisan directive. These were funds that were given to election sites. They were not given based on people that needed to vote.
Mr. Chair,
Senator Westlin.
can you help with this? Again, to just put a fine point on that, and then I would like to move on from that. That is not the topic of this bill. Number one, the state only started providing funding to local governments for elections in 2023. My understanding, and I was not here, but my understanding is the funding that was being provided was being given to local authorities trying to administer elections during a pandemic. And as Senator Carlson indicated, it was not money that was given to voters. It was given to municipalities and election officials to operate their elections. Having said that, I'm thankful for Senator Carlson for sort of intervening, but impugning motives is probably not appropriate. I don't have intellectual dishonesty. As I said earlier, had I been here at the time, I would have heard the information. We are not talking about similar situations. I have objections to billionaires influencing our elections, and frankly, that's what I hear from voters. I hear from voters that they are tired of the undue influence, and it's not just billionaires, it's millionaires. It's corporate interests that provide donations to IEs, and it is dark money. Dark money is an enormous problem in our elections. Frankly, we would all probably be better off if we had publicly funded elections. We would probably be better off if we had true transparency in funding for our elections. And I keep hearing people on this committee talking about dark money and so on, then I will look forward to your full support for this bill. Senator Cran said this has no chance of moving forward. Well, of course it has a chance of moving forward if all the folks on this committee are as opposed to money and influence in our politics as I am and as our voters are. This is a sensible bill. It closes a very specific loophole. It makes sure that in 2026, nobody in this room, nobody running for election in this state is going to have some big money coming in from whatever source, enticing people to vote, to register to vote, to sign a petition in exchange for money. And I think that that is a very clear distinction that we should and can make in this committee, and that is something that we can do something about today. We cannot do anything about Citizens United. We have had many conversations about that. We have sent a resolution or tried to pass a resolution to Congress to do something about Citizens United. They aren't going to do anything about it. But we here in Minnesota can do something, and we should do something to shore up the integrity in our own elections and make sure that people are not bribed for their votes.
Senator Lucero.
Thank you, Mr. Chair. So the question, Mr. Chair and Senator Westlin, would you be willing in the objective to stop billionaires from influencing Minnesota elections? If this were to move forward, would you be willing to accept an amendment that would prohibit Mark Zuckerberg or other billionaires from influencing elections like they have in the past?
Mark Zuckerberg is a billionaire. Thank you, Mr. Chair. Senator Lucero. This bill would prohibit any billionaire, including Mark Zuckerberg, from coming to our state and paying voters $100 to sign a petition to oppose activist judges or whatever his thing might be. This already covers that. It doesn't matter what the political affiliation is of the money that's coming in or the people who are putting the money up. It applies equally to Democrats and Republicans. And again, I would think that is something that we could all get behind. There's no need to amend it. We aren't saying Republican billionaires, we are saying billionaires. We're talking about the influence of money in our election. And I have never once indicated that it was only one party or the other. This precludes people from paying people to sign petitions and to otherwise try to influence people on their vote.
Final remarks, Mr. Chair.
Oh, Senator Lucero.
Thank you, Mr. Chair. One of the things I learned a long time ago, never underestimate one's ability to rationalize. Thank you.
Senator Marty.
Thank you, Mr. Chair. The bill doesn't mention billionaires here, and I guess I just go back to the simple premise here that bribery is not something we want in our elections. 100 years ago, there were a number of cases where people would go out and bribe people directly, free drink or something in order in exchange for voting. This does not, the case that she gave is of a billionaire offering this kind of bribery, but the point here isn't about any other thing. It's about simply that bribery is wrong. We ought to do it. I can't see a lot of the objections people are saying is about other things they think are wrong, that they think other people support, even if those other people don't support them. This is simply a bill about stopping bribery. I think it's a good bill, and I urge you to support it.
Senator Westlin. Final comments.
Thank you, Mr. Chair. Interesting concept, rationalizing. So I certainly hear a lot of rationalizing for not voting for this bill. That's fine. Everyone on this committee can vote their conscience. But this is literally trying to close a loophole to make sure that here in Minnesota, people cannot come in with their money and their power and their influence and attempt to bribe voters for their vote. It is that simple. It will be an interesting rationalization that one must go through in order to vote no. Thank you, Mr. Chair.
Thank you, Senator Westlin. And we have had a roll call requested. I need to say one more thing, and that is that I agree strongly with Senator Westlin that this is not a partisan bill. This is a bill that I think all of us can get behind. We need to limit this dark money from whomever it comes from, and because I think we know that it's going to get worse. This is not going to solve itself. So we need to put our shoulders to the wheel here, and I'm hoping that we can get, if this one doesn't get it all the way, I'm hoping we can get the entire committee behind getting it tuned into getting rid of this kind of influence. So with that, the clerk can please take the roll.
Senator Carlson.
Yes.
Senator Curran.
No.
Senator Westlin.
Yes.
Senator Barr.
Aye.
Senator Bolden.
Aye.
Senator Swazinski.
Yep.
Senator Limmer.
Yes.
Senator Lucero.
No.
Senator Marty. Senator Matthews. Senator Port.
Yes.
Seven ayes and 4 nays. The bill is passed as recommended, and it is referred to it's going to go to Judiciary Committee first. So the motion is passed. Senator
Thank you,
Westlin,
members.
your next bill, Plain Language Lobbying Handbook.
Thank you, Mr. Chair. Senate File 2021 is a bill that provides or directs the Campaign Finance and Disclosure Board to provide a handbook for lobbying. In 2023, requirements regarding lobbying were passed per the Campaign Finance Board's recommendations. After feedback regarding these new requirements that found some of the provisions confusing to newly registered lobbyists, the requirements were paused until the end of 2025 session. Senate File 2021 requires that the Campaign Finance Board publish a lobbying handbook in order to assist lobbyists and advocacy groups to guide them on which activities require disclosure. Senate File 2021 requires that the Campaign Finance Board publish a lobbying handbook written in plain language on the board's website. This handbook must include registration requirements such as when someone is required to register as a lobbyist and what activities are considered, quote, lobbying, unquote, which activities are expenses or expenses don't count towards the dollar amount threshold, and any differences between lobbying the legislature, executive branch, political subdivision, or Public Utilities Commission. The CFB would also be required to regularly update the handbook to reflect changes to statutes and rules. In creating this handbook, the CFB would be required to consult registered lobbyists, including lobbyists from nonprofits, small organizations, and organizations led by our BIPOC community. So with that, Mr. Chair, I believe there are 3 testifiers on this particular bill. Marie Ellis, Lily Abisso, Kate Klassner.
Testifiers, please come forward. And I have Ms. Marie Ellis as the first one on the list. So Ms. Ellis, please identify yourself and the organization you represent and proceed with your testimony.
Thank you. Good afternoon, Mr. Chair and members of the committee. My name is Marie Ellis, and I'm here representing the Minnesota Council of Nonprofits. MCN is the largest statewide association of nonprofits in the country, representing over 2,000 member organizations across the state. Our mission is to inform, promote, connect, and strengthen individual nonprofits and the nonprofit sector, and much of that work is done through our public policy advocacy and lobbying initiatives. MCN's focus on lobbying regulations is twofold. First, that lobbying rules and procedures be clear so that nonprofit staff can easily understand if they need to register, and if so, what must be reported as lobbying activities. Second, we recognize the necessity for strong transparency in lobbying to maintain public trust in the policymaking process while ensuring that nonprofits can effectively advocate for their communities. Specifically on this bill, MCN supports Senate File 2021, and we are looking forward to working with the Minnesota Campaign Finance Board on clear, practical guidance that facilitates transparency and accountability. One of the best parts of my job is encouraging nonprofits to share their expertise with elected officials. MCN strongly believes that good public policy is best built by the meaningful exchange of ideas between lawmakers and their constituents, including nonprofits. Without those voices in the conversation, the policymaking process would certainly lack critical perspectives. There's an unfortunate misconception that nonprofits cannot lobby, and most people don't immediately understand the nuances between advocacy and lobbying. MCN supports guidance so that nonprofits and others can easily comply with registration and reporting requirements and avoid unintended violations. Thank you. Okay.
Thank you, Ms. Ellis. Now, Ms. Ilili, Ibiso, can you help us with your correct pronunciation?
Okay. Chair Carlson, members of the committee, my name is Ilili Ebiso with Clean Elections Minnesota, a nonpartisan nonprofit that advocates for a healthy and inclusive democracy. I'd like to thank you for the opportunity to speak today in support of SF 2021. I would like to thank Senator Westlin for championing this important bill. Transparency and accessibility are the foundations of a fair and democratic government, and that's exactly what this bill promotes. Right now, navigating Minnesota's lobbying laws can be confusing, especially for individuals and organizations that don't have the resources of large and well-funded lobbying firms. This bill ensures that all Minnesotans, regardless of their background, can engage in the legislative process with clarity and confidence. By requiring the Campaign Finance and Public Disclosure Board to publish a plain language handbook, this legislation removes unnecessary barriers to civic participation. It will clearly outline registration requirements, reporting obligations, and distinctions between different types of lobbying, ensuring that everyone from grassroots advocates to small nonprofits understands their responsibilities under the law. Critically, this bill also requires input from lobbyists outside of the traditional professional sphere, including those from nonprofits, small organizations, and communities of color. These voices are essential in shaping guidance that reflects the diverse ways Minnesotans engage with their government. Government should not be a system that only the well-connected can navigate. This bill promotes transparency, accountability, and fairness, giving every Minnesotan a chance to make their voice heard. I urge you to support this common sense reform. Thank you.
Thank you, Mr. Biso. Next, we have Kate Klossner. Please identify yourself for the record and continue with your testimony.
Thank you. Good afternoon, committee. For the record, my name is Kate Klossner, and I'm testifying on behalf of the Minnesota Government Relations Council, or MGRC, where I volunteer as our legislative chair. MGRC is a Minnesota nonprofit organization that serves as a trade association of sorts, of government relations professionals with one common goal: ethical representation at the Capitol. Ethical representation and adherence to the laws governing our community are our core values. For several years, we've worked very closely with the Campaign Finance Board on legislation relating to lobbying regulation and public disclosure, as we too share the goal of a very transparent public process. Throughout the years, our members have been very clear. The bills that have passed over the past few years have greatly expanded the definition of lobbying and who needs to register as lobbyists. And coupled with the new definition of legislative action, there has been considerable confusion among our community about who needs to register. So because of this, MGRC supports the handbook for lobbying outlined in Senate File 2021. This resource will help clearly explain registration requirements, including what activities trigger registration and how those requirements relate to specific employees in our client organizations. For our members, for the most part, we're already registered as professional lobbyists. For many of us, it is a core function of what we do. However, for many other employees within the organizations we represent, there are still questions about when to register, how to register, when to report, what to report, that we think this handbook will help answer. It will provide much needed information very clearly to people who are not as immersed in the Capitol as we are from day to day. We share the goal of this committee in facilitating proper registration of the appropriate people and making this information as clear and accessible as possible, which will help reduce omission by ignorance or confusion. So MGRC and the lobbying community we represent are invested in ethical, transparent representation, and we want to ensure the same clarity and regulations for our community and for the general public. MGRC supports this handbook for lobbying and looks forward to including a link on our website so that our members can send out to their clients. Thank you for the opportunity to testify, and I'm happy to answer any questions.
Thank you, Ms. Klasner. Senator Westlin, any comments at this stage?
I have none.
Okay, member questions? Senator Lucero.
Thank you, Mr. Chair, and thank you, Senator Westlin. I definitely am one who is a proponent of plain language and making sure that we have comprehension for all those who are reading the material that they are looking at. I am also a strong proponent, as you know, Mr. Chair and Senator Westlin, a strong proponent of freedom from discrimination. I champion those for being able to pursue happiness in our republic free from discrimination. And when I look at the human rights statutes, just as a reminder, Mr. Chair, it is the public policy of this state to secure persons in this state freedom from discrimination in regards to race, color, national origin, and others. And it goes on to say, such discrimination threatens the rights and privileges of the inhabitants of this state and menaces the institutions and foundations of democracy. So, Mr. Chair and Senator Westlin, as I'm looking at the bill on line 2.2, you are specifically seeking to have consultation by organizations that are led by people that are Black, Indigenous, and people of color. So my question, Mr. Chair and Senator Westlin, how does one consult with a person of color seeking their advice and or feedback over the advice and feedback of others that might not be a person of color at the same time of upholding the freedom from discrimination against persons of color?
Senator Westlin.
Mr. Chair, Senator Lucero, I really don't understand your question. I certainly understand the point you're trying to make. If you look on page 1.19 to 1.21, it says, in developing and updating the handbook, the board must consult individuals who are registered lobbyists, but who are not full-time professional lobbyists, including lobbyists, going on to the next page, for nonprofits, small organizations, and organizations led by individuals who are Black, Indigenous, and people of color. This is seeking to get input from organizations that may not have the same size, influence, et cetera, and to make sure that we are getting input from all corners and not just the corners of the large lobbying firms. So no, Senator Lucero, this does not violate the Human Rights Act.
Senator Lucero, follow up.
Thank you, Mr. Chair. So it's unfortunate that Senator Westlin didn't understand the question, so I'll try to rephrase it.
Great.
So the bill is seeking to call out people of color, and in doing so has to discriminate against other people. And so the question is, how does the act of discrimination, as the plain language of the bill, adhere to the principles of not discriminating against people of color?
Mr. Chair and Senator Lucero, it's not discriminating. It is saying that those organizations that may be led by those individuals should be consulted and included. It is not excluding anyone. So I guess, with all due respect, I reject the premise of your question.
Senator Lucero, are you complete?
I'm good, thank you.
Okay. Senator Swazinski.
Thank you, Mr. Chair. Thank you, Senator Westlin. I just want to thank the Campaign Finance Board. I do believe this may be the second time this session that they've put in their fiscal note that they're willing to absorb the 100 hours of work. And so I just want to publicly thank the Campaign Finance Board for taking on the extra work that this bill will have them have to do. So that's all I have to.
Senator Swazinski, thank you for thanking them. Senator Grant.
Thank you, Mr. Chair. Thank you, Senator Westlin. On 1.19, regularly updated, so there's no, I mean, when would you expect the changes to be made? Just whenever something changes? Or do we want to at least make sure it's updated at least twice annually, every 6, right? It seems like a pretty broad term. How will campaign finance know when they should update it?
Senator Westlin.
Mr. Chair, Senator Cran, I think the plain language says when there's been a change to the statute. So if there's a year that there haven't been any changes to statute, I assume that they wouldn't update the handbook. But I don't know if Mr. Sigurdson has anything to offer on that, but it seems to be that the update is linked to changes.
Okay, thank you. Mr. Chair, follow-up.
Grant.
Senator Westlin, I don't want to belabor the point on the, similar Senator Lucero brought up, but the, why would we exclude, one, I don't know how they would, right? You basically saying they should talk to everybody. I don't know why we would eliminate those that operate in a full-time profession with all the changes that are necessary. I think that they should consult with a wide variety of people. They wouldn't know to even know how to target or exclude or include based on the description and based on the information they have. But they have, as they roll these out and into that plain language, they're probably the most knowledgeable and skilled to be able to provide positive feedback. If the stated goal, or as it was stated, because a lot of new people were caught up into this process, they may not know the nuances in as it stands today, or even in the plain languages, that you just wouldn't seek input. I think they could provide great value. So I think that that line probably isn't even necessary. Besides, consult with people who are registered lobbyists and cover them all.
Mr. Chair, Senator Cran, I think the intent here is to create a handbook that is understandable. And as we know, the larger firms, the people who regularly lobby, are pretty familiar with the statutes and laws. And the intent here is to look at organizations that maybe don't do this quite as often, because if they understand what's in the handbook and they understand the requirements, other lobbyists will. And so the idea is to consult with the nonprofits and other organizations that may be smaller. And again, it's the intent is to make sure that this is plain, it's understood across the board, and not just by the people who do this more often.
Mr. Chair, and Senator Westlin, I agree, but I think that as you move out in the plain language, you'd want as many eyes on it as possible to create that communication channel. They'll likely communicate it anyways, but that's my point. Include all of them. They can probably help and provide a great set of eyes. They are the experts in this field. And so to exclude the experts and hope that somebody else is going to figure it out in a group that it's maybe completely brand new, as many are going to be sucked into being registered as lobbyists, it just seems that would be much more beneficial to have them at the table and include them than exclude them. So thank you.
Mr. Chair, just for clarity, I don't think they're being excluded. I don't think there's anything that prevents other lobbyists from having input. It's just saying specifically we do want to include these folks, number one. And number two, I'll just say the MGRC does support the bill, so they apparently feel that it is good language. Make sure that everybody knows what the rules are.
Final comments, Senator Westlin.
It's a good bill. I think we're laying it over.
That is correct, Senator Westlin. The bill is laid over for possible inclusion in the omnibus bill. Your next bill is, if I read this correctly, is Senate File 1662, exempting submission of a proposal in response to an RFP from the definition of lobbying.
Thank you, Mr. Chair. Senator Bonnie Westlin, testifying today before the committee. So Senate File 1662 is actually the result of a report that was completed by the Campaign Finance Board. There are already some rules adopted by the board, and this basically is codifying rules. There have been discussions during the development of the report that raised questions about whether submitting a request for proposals or grant application could qualify as attempting to influence the official action of a public subdivision and thus require lobbying registration. This essentially states that Lobbying, that defines lobbying as an attempt to influence a non-elected local official. It also clarifies that the mere act of submitting a grant application or responding to a request for proposals or other administrative or technical communication regarding those grants are not considered lobbying. It provides a non-existent exhaustive list of what is considered a major decision regarding public money, and it contains a non-exhaustive list of what is not considered a major decision. We do have an amendment. It is an author's amendment, and that amendment, Mr. Chair, we can deal with that, but that repeals the CFB rule that is actually codified and makes sure that there would not be a conflict between this language and that rule.
We do not have a copy in our packet, so council will explain the A1 author's amendment.
Oh, go ahead.
Mr. Chair, we can do it as an oral amendment. It would be adding section 2 on page 2 after line 9. It would be to add section 2, which is a repealer, and it would be repealing Minnesota rules, part 4511.1100.
And again, Mr. Chair, it is the CFB rule, which is being codified and updated by this bill.
Thank you, Senator Westlin. This is an author's amendment. All those in favor say aye.
Aye.
All opposed, nay. The amendment is adopted. Senator Westlin.
I do have one testifier, Ms. Ellis.
Hello, everyone. Me again, Marie Ellis, Minnesota Council of Nonprofits. You will be seeing me on the final bill too, so get ready for that. I'm here to say that we greatly appreciate the provision in this bill that clearly states it is not lobbying if a nonprofit or another entity is responding to a local government's request for proposals for a grant program. We also appreciate clarity that communications of a purely administrative or technical nature about these RFPs are not lobbying. When an organization responds to an RFP that may result in the organization receiving funding for performing specific services, it is not an organization lobbying for funding. Rather, it is an organization answering a unit of government's call for partnership. Additionally, responding to state and federal RFPs is not currently considered lobbying, and there's no reason why local government RFPs should be viewed any differently. Thank you for the opportunity to speak to that provision, and we ask you to support it.
Thank you, Ms. Ellis. Do we have questions from members? Would you like to have some final comments?
I think Senator Barr would like to.
We have a Senator Barr.
Thank you, Mr. Chair. I'm Senator Westlin. I'm just a little confused. Can you help me out?
I will do my best, Senator.
So line 1.18.
Yes.
The development and ratification of operating and capital budgets. And then line 2.5, which is not lobbying, purchasing goods of public funds and operating and capital budgets. Help me clarify that in my mind, because to me, I'm looking at this, you can't lobby, one side is lobbying on purchasing capital funds and operating whatnot, and then it's not. So I'm missing something here. Help me out.
Mr. Chair, I would like to phone a friend, and I would like to have Mr. Sigurdsson come and help out with that question.
Mr. Sigurdsson, please identify yourself for the record and continue with your response.
Committee members, Jeff Sigurdsson with the Campaign Finance and Public Disclosure Board. Senator Barr, the difference is that, for example, if you were lobbying for inclusion in the operating budget of a city for specific funds to build a new fire station or to include funding for fire engines, that would be lobbying because you're trying to increase the overall budget or at least specify items that will be included in the overall operating budget of the city. On the other hand, if you're dealing with, this goes back to the idea of selling items, if you're coming back to the fire chief and say that, okay, you've been authorized X number of funds to buy fire engines, here's the model we believe that you should buy, we're trying to sell this to you, that is not lobbying. That's reflective of what's already in state statute, that trying to sell goods that will be purchased with public funds is not considered lobbying. So that was the distinction that the rule was trying to make.
Senator Barr, follow.
Thank you, Mr. Chair. Mr. Sigurdsson, so my question would be, if you have a city and a couple of, let's just say 2 or 3 neighbor moms, families get together and say, we need a park, or we need new, we have this area that we would like the city to develop into a park and put some playground equipment in it. You're lobbying the city for an expenditure that's going to have continuing upkeep within that. So does that fall into the definition of the first one, where like we're asking for fire equipment that will have upkeep, or a new fire station, so we're asking for a new park with playground equipment? Would that fall in that same definition?
Mr. Sigurdsson.
Mr. Chair, Senator Barr, it might, but remember that all of these definitions are sort of interrelated. For the definition of lobbying, you have to be compensated over $3,000. So in your scenario, it's unlikely that the neighborhood group, anyone's paying them to do anything. So when they come forward asking for the city to look to develop a new park or baseball field, they probably are not being paid, and therefore they won't need to register as a lobbyist.
Follow up?
Senator Barr.
Thank you, Mr. Chair. So, Mr. Sigurdsson, so if the fire chief comes in, he's getting compensated because of he's getting a check? Does that, he's not getting paid as a lobbyist, but if he's the fire chief and said, we need a new engine, or we need the building's leaking, we need this, he's requesting funds, but he's not being paid as a lobbyist. Just, I know this sounds kind of technical, but I'm just trying to understand where exactly the lines are at.
Mr. Sigurdsson.
Mr. Chair and Senator Barr, again, because of another provision, they would not, the fire chief would not be. There's a provision that says that if you're an employee of a political subdivision and you're lobbying your own city to do something, in other words, in your example, the fire chief asking for this new station, that's not lobbying because they're an employee of that city. And by definition, that's not a lobbyist. So there are some exclusions that try to, I guess, have looked at this sort of issue, and we don't want to bring in people and require them to register and report as a lobbyist when it's really part of their city or official duties for the city to provide information to the city and council on what they believe would be best.
Senator Barr.
Thank you, Mr. Chair. Thank you, Mr. Sigurdsson, and I'm really looking forward to seeing that handbook, because I bet you all the clarifications for all these silly questions are in there. Thank you.
Thank you, Senator Barr. Senator Westlin, final comments.
Thank you, Mr. Chair. I believe this bill is also being laid over.
Yes, the bill will be laid over for possible inclusion in the omnibus bill. And continuing with Senator Westlin Day, you have your next bill is 2562. Campaign Finance Public Disclosure Board's lobbying recommendation.
Thank you, Mr. Chair, and you'll all be happy to know this is not only the last bill of the day, but the last bill by me of the day. Senate File 2562 is a compilation of the lobbying recommendations that were compiled by the Campaign Finance Board based on feedback from a public forum where the board heard from multiple stakeholders. These recommendations include well-balanced reforms to clarify who needs to register as a lobbyist while also maintaining existing protections. To go through the bill, Mr. Chair, sections 1, 2, and 5 regarding expert witnesses. It's redefining expert witnesses and exempt such expert witnesses from registering as lobbyists as long as their communications occur in public forums or is made available to the public. Lobbyists are required to report information on any expert witnesses which communicate with public or local officials at their or a principal's request, including details on who testified, which officials were lobbied, and the subject that was discussed. Section 2, definition of lobbying. Non-elected local officials and employees of political subdivisions are not required to register as lobbyists, which we just discussed, unless they spend over 50 hours per month attempting to influence governmental actions. This change preserves this existing requirement that public employees must register as lobbyists when they exceed the 50-hour threshold for attempting to influence governments, but clarifies that working with other local governments on joint powers agreements or other technical work does not require registration. Section 3, metropolitan unit of government. This amends the definition of metropolitan unit of government to include a regional railroad authority in the 7-county metro area. Sections 4 and 6 through 9, county commissioners, soil and water conservation district supervisors, and watershed board members have been removed from the definition of public official for clarity regarding if they are covered by lobbying registration requirements. And again, this is in fact based on recommendations made from the Campaign Finance Board in terms of changes made to this section of statute. We do have 3 testifiers, Mr. Chair.
I'll be around.
I may need you.
We have 3 testifiers. Ms. Amy Wallstein from MGRC, Vice President. Laura Ziegler from Associated General Contractors of Minnesota, and Marie Ellis from the Minnesota Council of Nonprofits.
Good afternoon.
Ms. Wallstein.
Good afternoon, Mr. Chair, and I want to thank Senator Westlin for her continued work to help clarify. My name's Amy Wallstein. I'm with the Minnesota Government Relations Council. We're an organization of 626 government relations professionals. We're the lobbyists you see up here at the Capitol, and lots of other folks who you don't always see. But we have been engaged in this conversation on the on really the regulation of our industry for the last few years. And so we appreciate the conversations that have occurred as we've been on a journey to seek clarity on the 2023 changes to who must register. There's been an expanded universe of who must register and for what activities, because the definition of legislative activities changed slightly in 2023. So it's caused a lot of questions to come up. And so we have talked with our members continuously over the last few years. We've engaged in the study group, we've engaged in rulemaking, and we've been talking with legislators as well. We've worked through a lot of the questions that we've had. I think we now have about 4 things that we're still kind of looking at and seeking clarity on. And one of those things is addressed in this bill on subject matter experts or expert witnesses. So we appreciate the work to clarify like what the line in the sand between when you are advocating and professionally as a lobbyist, when you're lobbying and when you're consulting. So that's the line that we're trying to find, is between when you're consulting and when you're advocating. So we're supportive of the clarifications for subject matter expert. I think we have some questions on the Public Utilities Commission piece of it that we'd like to continue to discuss. Another thing we're still hearing from our membership is on engagement at the local level, and some clarifications on that, which we've discussed today as well. We're also hearing kind of on the grassroots lobbying side, like what we seek some clarifications on day at the Capitol, and when when lobbyists or organizations are bringing people to the Capitol, and how much of that is advocacy or grassroots, or so we're still kind of thinking through what that could look like if we had more clarity on folks engaging at the Capitol. Because we have heard from some of our members that organizations have refrained from holding days at the Capitol due to some uncertainties. So we'd really like to get that clarification accomplished. And then the other piece that we're still hearing about is confidentiality, attorney-client privilege sometimes, or confidentiality in lobbying relationships, so we'd like a little clarification that we wouldn't have to provide any information in our registration materials that would cause us to impact our confidentiality. So those are just a handful of things that we're still kind of working through, and we appreciate the conversations in this committee on kind of getting to a deeper understanding. We think the handbook will be helpful as well, and we would be happy to be consulted. Thank you.
Mr. Chair,
Senator Westlin.
I should have mentioned this in my initial remarks, and we are continuing to have conversations, and I know that there may be some minor tweaks to this. I think my understanding coming into the hearing was that MGRC was neutral on the bill, but that we were continuing to work on some very smaller, minor tweaks. That was my understanding. So we will continue to, yes, have conversations.
Thank you for your testimony. Next on the list is Laura Ziegler from the Associated General Contractors.
Good afternoon, Mr. Chair, members of the committee. My name is Laura Ziegler with Associated General Contractors of Minnesota. It's not often that I am in front of your committee, but it's a pleasure to be here, and thanks for having me. In the interest of your time, we coordinated comments with the American Institute of Architects here in Minnesota, as well as the American Council of Engineering Consultants. And so these viewpoints also reflect those associations. When the law governing lobbying was amended in 2023, as you've been discussing here this afternoon, the architectural, engineering, and construction workforces that we collectively represent did not realize that when all the changes were taken together, the law could be interpreted to mean that their day-to-day work in front of local units of government in particular might be considered lobbying. These professionals regularly advise or appear before planning and zoning commissions, as well as city councils, to provide technical expertise on housing, transportation, and other infrastructure projects. They explain how a project interfaces with zoning ordinances. They advise on building codes, seek necessary building permits, and the like. And while they may present information on projects that require variances or budget change orders, they do not advocate for broad policy changes or budget changes. Our organizations have engaged with the Campaign Finance Board study process over the interim, and we appreciate that Senator Westlin's bill acknowledges the need for further clarity in the law with that nod to the expert witness language. And so we're actively working on additional language that would fully address our collective concerns, and look forward to that continuing discussion. Our general recommendation for a law change is to make clear that these professionals and workers on local projects filing the necessary permits and those other examples that I talked about earlier, and making those recommendations are based on their expertise, their opinions on their education, training, and experience, and that they are not considered lobbyists. And to be absolutely clear, we are not interested or seeking to create any sort of loophole for people that are engaged in direct advocacy of local officials, nor are we looking to prevent professionals that we represent from having to register as lobbyists if they are engaged in separate advocacy here at the legislature versus that local unit of government that we're talking about. So right now, architects, engineers, our construction workforce, we're a little bit in limbo. So we want to clear that up and look forward to continuing the conversation. Thank you for your time.
Thank you, Ms. Ziegler. Marie Ellis, Minnesota Council of Nonprofits again.
Thank you, Mr. Chair. The Minnesota Council of Nonprofits supports this bill, and we'd like to specifically address the expert witness provisions. As you all know, the most powerful and impactful testimony often comes from people with direct personal experience on the issues at hand. Staff at nonprofits often are those people. They work directly with programs administered or overseen by the state and can share whether proposed changes are feasible and how those proposed changes would impact the people they work with every day. When I was in a previous role at a large human services nonprofit, it often made much more sense for program staff people to be here talking with you all. As a lobbyist at the organization, I could have brought their ideas and concerns to you, but their direct connections to the work allowed those staff to be able to answer your questions with specificity, nuance, and examples. We think that the expert witness provisions outlined in the bill would give clarity to nonprofits to differentiate between staff experts and registered lobbyists. And I can't overstate how important it is for lawmakers to hear from people with real-life experiences with the laws you're considering changes to. Overall, we think this bill strikes a good balance of promoting and requiring disclosure without stifling civic engagement and creating unnecessary burdens for experts to share their expertise with you. Thank you.
Thank you for your testimony. Any comments or questions from the members? Senator Barr.
Thank you, Mr. Chair. Senator Westlin, I know you said that you're going to continue, you've got some tweaks to make, and I'm curious on lines like 3.1 to 3.3. Says an expert witness who communicates with public or local officials other than the Public Utility Commission. So why did you single out the Public Utilities Commission?
Senator Westlin.
Mr. Chair and Senator Barr, I can phone a friend on this, but my understanding of that is that it is because all of their meetings and everything are public, and so there are no private conversations happening, but we'll see if Mr. Sigurdson agrees with my understanding.
Mr. Sigurdson.
Mr. Chair, Senator Barr, Senator Westlin is about 80% there. The PUC the Public Utilities Commission is unusual in that their members can only communicate with lobbyists in an ex parte, if I use that term correctly, setting, which means they cannot meet with a lobbyist one-on-one. They can only meet with them during a committee hearing or a commission hearing, excuse me. That changes the nature of what, how people are presented or testify in front of the PUC. The other issue, frankly, we excluded the PUC because it's such a different type of communication that they're having with the people who are communicating with them. If you look at the list, we looked at a few dockets that they had in front of them and the people who are going to be testifying, they were all engineers. I mean, you could argue that they're all experts and therefore that there wasn't anyone lobbying because Xcel Energy is bringing up people to talk about very technical items. So I'm not sure, the board just didn't feel like this was a scenario that we could cover the PUC without their input and without them helping define what would be a reasonable exclusion of expert testimony, because frankly it seems like everybody that appears before them is an expert.
Thank you for the explanation.
Are there other questions from the members? Senator Westlin, final comments?
I believe this bill is being laid over.
This bill is being laid over. So thank you, everyone. Senate File 2562 is laid over for possible inclusion, and that is the end of our business for today. The meeting is adjourned.